Modes of acquisition of state territory. There are five modes of acquiring territory which have traditionally been distinguished into discovery and occupation, prescription, cession, conquest and subjugation, and accretion. Before looking into these modes of acquisition, which have been derived from Roman law rules and property, it is necessary to understand that they are no longer appropriate or applicable. However, these modes of acquisition of territory still help us explain how countries got their titles. Discovery and occupation. Occupation is a state's intentional claim of sovereignty over territory treated by the international community as terra nullius, or territory that does not belong to any other state. Now, in the Eastern Greenland Peace, the International Court of Justice stated that claims to sovereignty based not upon some particular act or title, such as a treaty of cession, but merely upon continued display of authority involves two elements. First, the intention and will to act as sovereign, and second, some actual exercise or display of such authority. Prescription, on the other hand, is a mode of establishing title to a territory that is subject to the sovereignty of another state through the peaceful exercise of de facto sovereignty over a long period of time. Now, a title by prescription to be valid under international law, it is required that the length of time must be adequate and the public and peaceful exercise of de facto sovereignty must be continuous. The cession of a territory is a transfer of sovereignty from one sovereign to another, and its basis lies on the intention of the concerned parties to transfer sovereignty over the territory in question. And it rests on the principle that the right of transferring its territory is a fundamental attribute of the sovereignty of a state. Now, it may be voluntary as a result of a purchase, an exchange, a gift, a voluntary merger, or any other voluntary manner, or it may be made under compulsion as a result of a war or any use of force against the ceding state. Now, the fourth mode is the conquest and subjugation. Now, subjugation is the acquisition of territory by conquest followed by annexation, and this is a direct mode of acquisition, which is often called title by conquest. With the coming into force of the United Nations Charter, the acquisition of territory by conquest may no longer be legal under international law. However, to this day, some states persist in acquiring territory by the use of force, such as the invasion of Kuwait by Iraq. The last mode of acquisition of state territory is accession. This refers to the physical expansion of an existing territory through the geographical process, and it is the name for the increase of land due to some new formations, such formation may be a modification of the existing state territory. And for example, when an island rises within a river or when an island emerges in the maritime belt. In addition to that, under intertemporal law, the view that the rules in effect at the time of the acquisition should always be applied. So that is the five modes of acquisition of state territory and intertemporal law. Thank you.